A newborn baby is found dead in a trash bag, and a former University of Kentucky cheerleader is indicted for manslaughter. But here's the real legal question. Can prosecutors rule out the real possibility that the baby died naturally during birth or by accident afterward? Court is now in session. According to investigators, the defendant, a former University of Kentucky cheerleader, secretly carried a pregnancy and gave birth alone in her dorm room. The newborn was later found wrapped in a towel and placed in a trash bag in the room. The medical examiner concluded that the baby had been born alive and died from asphyxia and classified the death as a homicide. But the report did not identify the specific mechanism that caused the oxygen deprivation. During Miranda's questioning, the defendant reportedly told investigators that she gave birth around 4 a.m., that the baby fell onto the bedroom floor during delivery, and that she later fell asleep next to the baby. She said that when she woke up, the baby was turning blue and purple. At one point, she also told investigators the baby made a small whimper. She says she believed the baby was already dead. She wrapped the infant in a towel and later placed the baby inside a trash bag. Whether that explanation is believable is not the legal question. The legal question is whether the prosecution can prove it did not happen that way. Prosecutors will argue the evidence shows a pattern of silence, and that silence was intentional. They will say the pregnancy was concealed from the beginning. They will point out that no one in the dorm reported hearing a newborn crying after the birth. And they will argue there is a simple reason for that, because the baby was suffocated. Their theory is that the infant was born alive, and shortly afterward, the defendant deprived the baby of oxygen, either directly or by placing the child into the plastic trash bag, where breathing could not occur. Their medical expert will testify that the baby died from asphyxia caused by another person, not from natural birth complications. And prosecutors will emphasize one central point. This was not a random chain of accidents. It was a sequence. A pregnancy hidden, a birth hidden, a death hidden, and finally a body hidden. That pattern, they will argue, is not panic. It is intentional concealment from beginning to end. The defense will argue a very different story. They'll argue this was a concealed pregnancy, followed by panic, not homicide. Their expert may testify that unassisted births can involve oxygen complications, especially when no medical care is present. They may also point to a phenomenon sometimes described as pregnancy denial or concealed birth syndrome, where a hidden pregnancy ends suddenly in a chaotic delivery. In that situation, the defense will argue a young woman may behave irrationally. They will say the baby may have died during or shortly after birth, or possibly during accidental overlay while the defendant slept. The trash bag, they will argue, was only used after the baby had already died, as part of a panicked attempt to hide what had happened. But there's a deeper problem in this case that neither side can easily escape. So the court has a question for both experts. First, to the prosecution's expert. Doctor, you rule this a homicide, but your report does not identify the specific act that caused the asphyxia, only that the baby lacked oxygen. If birth complications or accidental overlay can also cause oxygen deprivation, you cannot medically exclude those possibilities. And if you cannot exclude them, how can you say with certainty that the oxygen loss came from the trash bag rather than from accidental means? Now to the defense expert. Doctor, your explanation requires several things to happen. A concealed pregnancy, an unassisted birth in a dorm room, no witnesses hearing sustained baby crying after birth, an accidental rollover, and then the baby being placed in a trash bag. Each of those events may be possible in and of themselves, but taken together, are you asking the jury to accept that all those unlikely events happened in the same night? Or is there actual medical evidence showing that they did? Now, my ruling. At trial, both sides may present coherent explanations supported by medical testimony, but jurors are instructed to use their common sense. Rare events do happen, but when a series of rare events must all occur together to explain a death, jurors may begin to question whether coincidence is really the explanation. Right now, the prosecution presents a pattern of silence, and the defense presents a pattern of panic. If the defense can show through credible expert testimony that natural death or accidental overlay remains a real medical possibility, The law requires the jury to consider that possibility. But if those explanations remain theoretical, while the physical evidence points towards suffocation, the prosecution's pattern may ultimately be more persuasive to the jury, because criminal law does not require absolute certainty, but it does require a conclusion that is grounded in evidence and common sense. This has been Crimes Digest, crime news cross-examined. Sometimes the most important question in the criminal case is not what might have happened. It is which explanation actually fits the evidence. If you want more cases examined this way, subscribe. See you in the next episode.